Well, just before I continue from where I was, I think I'm doing reasonably well on time. Can I just give the court two references that I meant to give this morning, just on a point my Lord Chancellor mentioned yesterday, which are in volume 7 at tab 115.
Oh yes.
Is the report, and the court will see that the date on the report from which we're reading, regardless of whether there have been any subsequent reports, is the 18th of March 1965. And if the court goes over the page, the relevant extract, and we had the whole report before Mr. Justice Fraser, but the relevant extract here includes the passage at 42 in particular, but 42 and 43. And we can see halfway down, Article 54 requires every contracting state to recognise the award as binding and to enforce the pecuniary obligations imposed over final decisions of domestic court. And the other spot where we've got a little snippet of the report is in tab 118, at the very back of tab 118. And there are three highlighted points on 3837. Top part was promoting an atmosphere of mutual confidence and stimulating larger private international capital flows and so forth. Mutual confidence, we say, reinforcing the Supreme Court in Micula's analysis of a multilateral web of obligations. At the bottom of the page, on the other hand, adherence to the Convention by a country would provide inducement and stimulate larger flow of private international investment to its territories, which is the primary purpose of the Convention. So you've got the sort of twin purposes of stimulating cash flow of capital and investor protection to allow that capital flow. And then the key one really is over the page, which is the mutuality point that I think your Lordship put to me yesterday.
And I'm afraid I haven't kept up. Which page
oh, I'm so sorry. It's the very back. If you take tab 119 and then flip back one page, we're in the back of 118. And the key one is really the one at 3838. While the broad objective of the Convention is to encourage larger flow of private international investment, provisions of the Convention maintain a careful balance between the interests of investors and those of host states. Moreover, the Convention permits the institution of proceedings by host states as well as by investors, and the executive directors have constantly had in mind that the provisions of the Convention should be equally adapted to requirements of both cases. So I only mention that in case there's a shadow of the point left that in the Travaux people were worried about the state enforcing and which way round the enforcement actions would be. It's beyond argument that it was designed to apply equally to everyone. But as I mentioned the report yesterday, I just thought I'd show you it is 1965 and that's it. If I can take the court, if I may, back to the ECT, there is one provision which so it's in the same bundle actually. One provision which it's in 106, tab 106. There was one provision that I didn't mention, and it is salient because of the length of the sunset clause being entirely consistent with the overall purposes of protecting long-term investments in the energy sector. We see it 47 on page 3631, which is almost at the back of tab 106. Article 47, just below no reservations, which I did take the court to. Any time after 5 years from the treaty, contracting party can give written notice of withdrawal, and then 2, the withdrawal takes effect 1 year after date of notice. So the minimum time that any country would be a party would be 6 years. And then, importantly, the applicability of the provisions of the treaty continue for a further 20 years in Article 47.3. So the provisions of the treaty shall continue to apply to investments made as of the date from the treaty takes effect for a period of 20 years from such date. So that's the very long sunset provision in Article 47.3, which does not sit well with the EU suddenly announcing unexpectedly that the whole thing doesn't apply anymore. So it cuts across the very clearly expressed intention that the rights conferred on investors under the treaty would continue to apply for the 20-year period in 47.3. It's very difficult to reconcile that.
20 years after.
Yeah.
withdrawal.
Yes.
If in year 2 there's an investment,
Yes.
if I've understood this correctly, and,
Well, it
and
has
4
to be
years
year
later-
5. Earliest you can serve notice is year 5.
Yeah.
It
there's
then
a-
takes effect in year 6.
Yeah.
Then you've got
There's a
20 years
20-year
afterwards.
period.
So it's a minimum of 26 years.
Yeah.
So the idea that one of the parties can come along and go, abracadabra, it doesn't apply anymore as of today and now back to the origins of time
Yeah.
is not exactly easy to reconcile with the express words of the treaty
No.
and the evident purpose in those provisions.
I understand that the EU has now given notice.
My lord, yes, I think just has. Spain has denounced in the Gazette, and so their 20-year period runs from 1 year from the effective withdrawal.
That's right. Denounced is different to giving
Have you-
notice.
Sorry, have you denounced or have you withdrawn?
There's a reference somewhere to Spain having denounced.
I think we put denounced in our,
I think we've filed a
chronology.
termination notice.
You said in your chronology they had denounced
And
on
that
the
might
14th
be
of
right.
May.
Spain denounced 154.
And we've got
oh, they
a,
have denounced, it's in 154.
Well, have we denounced or have we just filed a termination?
Well,
Because
I think it might matter, and perhaps Spain could tell me which the answer is. I think Italy left, and the plan was for everyone to withdraw. So I expect that the effect of what's been done is a withdrawal in accordance with the terms of the treaty. But we'll find out.
well, the translation in the official State Gazette is Spain denounced the Energy
Yes.
Charter Treaty. On this, by a note verbal on the 16th of April 2024.
Yeah, what's confusing is in the denouncement itself in the official gazette, which is actually in the bundle at 4521. It may be a translation issue, but
Yeah.
it's tab 154
Yeah, I'm just looking at it.
at 4521. What they say at the bottom is all of this is in accordance with the provisions of Article 47.2 of the treaty and Article 20.3 of the protocol. And 47.2 of the treaty is the date of withdrawal. So it appears that they're invoking the, as I understand it, from learned friend Mr. Miles, very kindly, Dr. Miles is going to check. But I think,
I mean, this is the official Gazette,
yes,
not the actual note verbal.
it's not the instrument,
So
it's the gazette.
maybe the Gazette has
Translated,
expressed it as denunciation.
Exactly.
but it's withdrawal.
yes. So I'm sorry,
Given that it's under Article 47.2,
it does look like withdrawal.
either way, it looks as if it's withdrawal.
Exactly, exactly. So in Italy obviously left under the withdrawal provisions on its own previously.
it's the denunciation is fine, but it's a termination.
It's a termination under the treaty under Article
Yeah.
47, I'm told.
Thank you.
Very good.
Denunciation is not intended to convey anything else, I'm
No.
told, very helpfully. So that's that point. Then the
Yeah.
that seemed to almost work. There was one point that mentioned
Rain start coming in when it rains, and our cup will be running over.
exactly. There's also the possibility of a Marilyn Monroe moment here as the fan sweeps past, which I'm trying to guard against as well. So it's a multi-faceted attack.
Yeah.
But so there was one point that I did want just to take the court to, if I may, which is in the Comstroy decision itself.
Yeah.
Because I mentioned this point of competence, which dovetails with the VCLT provision that I showed the court, precluding any contracting party from relying on its own incompetence.
That's 41.
Exactly.
Bundle.
And so we're looking in bundle 6 at Comstroy in tab 75.
Yeah.
And the relevant paragraph is paragraph 62, which is on para 62, which is at the foot of page 2807. And the court will see there, however, the exercise of the European Union's competence in international matters cannot extend in an international agreement, cannot extend to permitting in an international agreement a provision according to which a dispute between an investor in one member state and another member state concerning EU law may be removed from the judicial system of the European Union, such that full effectiveness of that law is not guaranteed. And that's one of the absolutely essential premises, which has been heavily criticised for the Comstroy decision, for two reasons. One is, it's not EU law they're asked to apply. It's absolutely plain in 26.6. Second, that is absolutely almost word for word breach of Article 41. So it's no surprise that I think
Because the reference to state in Article 41
includes a practice transfer to a contracting party for these purposes. So the REIO is treated as a contracting party by definition in the ECT, alongside and with equivalent status to the states. So I mean, it's also it's not a surprise to find 41, because otherwise pacta sunt servanda doesn't mean anything. Because afterwards you go, whoops, so sorry. And that's not the basis on which the good faith negotiation, agreement, performance of international obligations primarily rests.
Can I ask, Mr. Ballard said to us, I think more than once, that the real key battleground on this issue is whether or not EU law is related to international law.
Yes.
But that doesn't seem to me to be the be-all and end all of your arguments.
Oh, not at all.
Seems to be, that doesn't seem to be, I mean, that's one of your points, but it's by far and away
No,
not your first point
Not
or
at
your
all.
last point.
no. Well, no. I mean, I say that's also, with greatest respect, a hopeless argument in context, in any event. But there are all of the other arguments as well, which you know, they derive from the express word of the words of the treaty and the VCLT, normal VCLT provisions.
You showed us very briefly,
Yes.
maybe I misunderstood the time, you showed us very briefly Lord Collins's.
I'm just about to do that. Yeah. So the last two things,
Did
unless
anybody in, you may not know the answer to this, so don't worry if you don't. Did anybody in Comstroy actually raise with the European Court that this wasn't an EU case at all?
oh well that yeah. Well, so
It's a reference by the Cour d'appel de Paris
On
in
something
relation
completely
to a
different.
claim by a Ukrainian company against a Moldovan company,
I mean-
against Moldova rather.
yes.
Well,
Well,
neither of which are in the EU.
Some of the commentators have speculated that the parties might have been a bit perplexed.
I had
what would-
no interest in
They had no interest at all.
Well, I just slightly wonder why the Court of Appellant referred it in the first place.
Well, my lord, I mean, being candid, well, that's a separate point. I think they sort of felt obliged. The problem is the reach and a way that with the greatest respect, the European Union has used the duty of sincere cooperation is incredible. And much of it was well intended. But it does put member states in a incredibly difficult position where, and of course, everyone's generally an enthusiast for the European Union, so one starts from that position within the European Union. So, my lords, I've really only got two more things left, so I'm hoping to finish reasonably close to
Good.
between.
Okay, you're going to show us
2:30.
your comments, were you?
Yes, so it's bundle 9.
Yeah.
And it's tab 162, which is quite near the back. The tab's at the very top, slightly hidden.
Yeah. Come on. Yeah.
And so if I just take the tribunal, the court through it, the at 4785, we've got the tribunal's reasoning on the intra-EU issue. And sets out the parties' contentions, and it's salient there that, of course, the Commission was intervening, as it has done in many of these, in several of these cases, and did indeed in Macula in the courts of this country. So the arguments were made by both Spain and the Commission. And the essential argument in this case was broadly the same as it was in before the tribunal in the case which the court seized off now, the ICSID tribunal in our case. They resolved the same jurisdiction issue, which concerned the same ACMEA-based intra-EU objection. And the principal question is defined in 307, whether Article 26 ECT generates obligations between EU member states because the member states of the European Community were unable to contract obligations between them as regards the internal market, and for this reason the EU is a contracting party to the EC. And then within this main point at 308, the intra-EU disputes are outside the competence of the tribunal. Are the arguments for Spain and the Commission that one, mayor ruling applies to multilateral treaties such as the ECT, and the Mazda on Spain award to the contrary is wrong, because before Ms. Justice Fraser we had, I can't remember how many of the awards that all find in our favour, but lots of them. We haven't obviously troubled this court with them, but there was, can't remember how many, quite a lot.
One or two.
And then 2, EU law is international law. 3, EU law is paramount and displaces any other national or international provision, which is primacy, which parenthetically we'll see on any view is an internal principle of EU law.
Yeah.
EU law relevant to the issues in the arbitration applies to claims in the arbitration. And the ACMEA ruling is binding on the tribunal because it has to apply EU law. And in short, that is not accepted. And at B, the court first looks at does ACMEA apply to multilateral agreements? And after setting out the 2 relevant provisions in the ECT and ICSID as jurisdiction, the tribunal recites obviously Article 41(1) of ICSID, which is the one I took the court to earlier, judge of its own competence, we've already discussed that, and then we'll see at 315, so as far as the choice of law is concerned, the combined effect of 42.1 of the ICSID Convention and 26.6 is that the tribunal, which has jurisdiction under Article 26 ECT, applies by virtue of Article 26.6 ECT, the ECT Treaty and applicable rules and principles of international law. So that's the correct approach from an international perspective. 319 or 318, there are therefore three ways in which Spain and the Commission can argue the tribunal lacks jurisdiction. First is at 319. As a matter of construction, the ECT doesn't apply to the present dispute. Principal basis of the argument is because provisions relating to regional economic organisations, the tribunal has no jurisdiction because investment by an EU investor in another member state is not an investment in the area of another member state for the purposes of 26.1, which obviously doesn't get anywhere because the other member states are contracting parties. 320, the second way of putting the argument is to say that EU law is to be applied because it's applicable international law, EU law has primacy, and EU law precludes intra-EU investment disputes from being submitted to an extra EU dispute settlement. And the third way, which is a variant on the second, is to say that ECT dispute settlement provisions are inapplicable because they're inconsistent with the EU treaty obligations and therefore inapplicable by virtue of the VCLT or the ECT. And so they dispose of the REIO point, which I won't trouble the court with. And over the page at 4791, we get the disconnection clause point, about which the court's already heard something.
Yeah.
Nor is there anything express or implied to support the argument there's an implied disconnection clause. And in the Reef case, which interestingly, actually, my Lord Justice Phillips, Reef was an EU and a non-EU investor, I think, which is the example your Lordship put to my learned friend. The purpose of disconnection clause is to make clear the EU member states will apply EU law inter se rather than the convention. There was no need, because there was no disharmony understood at the time. And then if we go forward, if we may, they refer to the VCLT on page 4794, Article 31, Article 30 and 31, and 32 and 41 with agreements to modify. So I hope I've fairly shown anything that could help Spain in the VCLT. And G, the Acmea ruling, 4796, in determining the scope and effect of the Acmea ruling, it's important to put its background in context and to give a detailed account of its reasoning. The arbitration to which the ruling gave rise was UNCITRAL, seat in Germany, Netherlands, Czechoslovakia, BIT, by a Dutch investor against Slovakia. Sorry. The tribunal awarded damages against Slovakia, which sought in the German courts to have the award set aside on the ground the award was contrary to public policy because the tribunal was unable to make a reference to CJEU. And we saw from Advocate General Wathlay's opinion, there's a slight rider on that on the facts that Slovakian investors were still enjoying protection under those very same treaties. And then, so far as the material, the questions referred were, and you can see that the questions referred by the BGH were there, and then it recites actually the Advocate General's opinion, refers to it at 340 and recites the passage I took the court to already at 341. I'm going to tarry with that, and gives the CJU's answer, which we've already seen. And then there's a very helpful analysis of the crucial steps in the reasoning at 343, which actually is set out in numbered paragraphs on 4798. And the key ones, we'll just go through them. First one, an international agreement cannot affect the allocation of powers fixed by the treaties, or consequently the autonomy of the EU legal system, observance of which is ensured by the court. That principle is enshrined in Article 344 TFEU, which under which the member states undertake not to submit a dispute concerning interpretation and application of treaties to any method of settlement other than those provided for the treaties. And that's a reference there. The CJEU opinion 213 is the one where the CJEU says no to the unanimous mandatory requirement in the Lisbon Treaty that the EU shall accede to the European Convention on Human Rights, which I referred to earlier.
Yeah.
Just in relation to learned friends saying that the EU speaks with the voice of all the member states. It's a very good example of when it did the exact opposite.
Yeah.
The autonomy of EU law is justified by essential characteristics. All of this, as I think your Lordship observed earlier, yesterday, is actually largely court-made glosses on the actual provisions. They're not relying solely on the treaty provisions. And then characterised by primacy is point 4. And importantly, and I'll come to this, direct effect of the provisions, which are applicable to their nationals and to the member states themselves. Just pausing there, direct effect, parenthetically, is normally relied upwards by individuals against states, not downwards on individuals. So we'll come back to that in just very brief closing remarks. 5, those characteristics given rise to a structured network of principles, rules, and mutually independent legal relations
I don't know what this is, but it's getting ring. Could you possibly go and ring Wilford and Robin Olsen and get them to come here immediately, please?
I'll carry on
If you could. I mean, I don't know whether it's the microphones in the room or they were fiddling around in the roof, but I was told that the fiddling around in the roof was
it's now stopped.
to do with the heating.
As soon as anyone comes, my lord, I suspect it'll stop.
I'm sure it will, but maybe that's where we're getting it to stop.
Yeah. And then
Okay.
six, the principle of sincere cooperation.
Yeah.
And then 7, specific characteristics and the autonomy of the EU legal order. Again, very much a principle, a fairly elastic principle developed by the CJEU itself. And the judicial system being a cornerstone. And then the application as analysed by the tribunal at 344. Under the BIT, Article 8.6, this is the point I made earlier to the court, the tribunals were obliged to take account of the law in force of the contracting party. And that's the distinction that many commentators, including the Dashwood article I referred to,
Yeah.
have pointed out. The ECT does absolutely nothing of the sort. In fact, it positively says something else. Then, obviously, the point 2, the arbitral tribunal, not part of the judicial system. And then tethered to 8.7 of the BIT in paragraph 4 on page 4800. Consequently, the law applicable to the procedure. Limited review 5, and then by contrast with commercial arbitration, where requirements of efficient arbitration proceedings justified limited review, provided that fundamental provisions of EU law can be examined, etc. And then after the footnote, arbitration provisions under Article 8 of the BIT derived from a treaty by which member states agree to remove from the jurisdiction of their own courts, hence from the system of judicial remedies, back up by EU law disputes which may concern the application and so forth. And then finally, at paragraph 8 over the page, the passage on multilateral treaties. It's true that according to settled case law of the court, an international agreement providing for the establishment of a court responsible for interpretation of its provisions and whose decisions are binding on the institutions, including the Court of Justice, is not in principle incompatible with EU law. Pausing there, my lords, that's precisely the point that came out of the CETA authority that I showed the court before. I mean, absolutely straight down the line, well established, and in Comstroy they then they admit it and then sidestep it with footwork which is more than deft. The competence of the EU in the field of international relations, capacity to conclude international agreements necessarily entail the power to submit decisions of a court created or designated by such agreements. One would have thought it's all going the right way. But the second paragraph, in the present case, however, apart from the fact disputes falling within the jurisdiction of the arbitral tribunal referred to in Article 8 of the BIT may relate to the interpretation of both that agreement and of the EU law, possibility of submitting those disputes to a body which is not part of the judicial system of the EU is provided for by an agreement which was concluded not by the EU but by member states. So there's 2 points there. There's the Article 8 requires them to apply domestic law, which includes EU law, not the ECT situation, but also this BIT is not concluded by the EU. So there you go, you can't have that. And we've got precisely the opposite. I'm making a totally obvious point. This is, the ECT is actually convened by the EU and it's a party to it. So anyway, there's the deposit. The dispositif is again set out, repeated at 345. And then they deal with the 2 declarations we looked at with my Lord Justice Newey yesterday, 346 and 347, and 348, and in fact 349. So basically you get 22 of the member states under the obligation of sincere cooperation basically roll over completely. If I can put it in speedy terms, I'm sorry, in that way. 348, 5 then do the second declaration which qualifies the position on the ECT, and in fact Hungary alone resists. So you don't get all of the EU countries, and you certainly didn't get all the ECT members. And at 4803, you've got the first question as to whether the ACMEA ruling has any application, and there's consideration of Article 31 CLT, subsequent agreement regarding interpretation or application, etc. So every point fairly and squarely considered. And 352, what is being said there is the EU has competence in the field of international relations to enter into an international agreement providing for the establishment of a court created or designated by such agreements as regards the interpretation and application of their provisions, and whose decisions are binding on the institutions, including the CGAU, are not in principle compatible with EU law, provided that the autonomy of the EU and its legal order is respected. So that's referring to what the Advocate General said. And just sort of possibly speeding up a bit, I mean, if I take the court to the key paragraphs, given the time, 355, this is the decision. We've had opinion 109, which is, I've already referred to briefly, and then the essence of these decisions at 355 is contained in opinion 213. The Court of Justice has admittedly already stated that in regard to an international agreement providing for the creation of a court responsible for the interpretation of its provisions, whose decisions are binding on institutions, including the Court of Justice, is not in principle incompatible with EU law. That's particularly the case, whereas in this instance, the conclusion of such agreement is provided for by the treaties themselves. So, it's pausing there. I haven't taken the court to all of the treaty mechanics by which the court is bound by the international treaties, but we have it within that quote already. So, it's there established. The court analyses 4805 EU law as international law.
Just before you do, I mean,
Sorry.
the punchline for everything that you've done so far is 356,
Yes,
where
exactly.
the tribunal says, we'll assume that ACMEA would be applied to the ECT. So that's the starting point. This is pre-Comstroy. They make that assumption.
Exactly.
And so far, everything is leading up to that, isn't it?
It effectively is, my lord, yes. So then, so that's the assumption which they, at that point,
And
On which
they
they
showed
then-
some foresight because Comstroy followed.
exactly. So it's quite helpful, as your lordship rightly points out, that that is included in the analysis. It's an assumption that foreshadows construct, as you say. And then at H, EU law is international law and primacy of EU law. 359, in the view of the tribunal, the point that EU law, or most of it, is international law, or the rulings of the CJEU are part of international law, is not in any sense conclusive. The question still remains as to whether EU law and the rulings of the CJEU are part of the applicable international law. The second point is it's been established for more than 50 years that it's a fundamental principle of EU law that the EU has created its own legal system, which is an integral part of the legal system of member states, in which their courts are bound to apply. The third point is the system of references under what's now 267 to ensure proper application, uniform application of the EU law, and then 362. But even if, as a matter of EU law, final determination of its content is reserved to the CJEU, it does not follow that non-EU courts and tribunals are precluded from deciding issues of EU law. Indeed, it would be absurd if a court in a non-member state, which otherwise had jurisdiction over a dispute, but could not make a reference to the CJEU, would have to refrain from dealing with issues of EU law raised by a party.
Yeah.
So a breach of contract case in somewhere else, and they say, well, I was required to do it by a directive, at which point everyone goes, we've got to stop the proceedings. I mean, there are people deciding those points all the time. Same must be true for arbitral tribunals, a fortiori for international tribunals. And then, although phrased in terms of interpretation of two provisions of the TFEU, it's hard to read the ACMER ruling as a normal case of treaty interpretation. Since Article 267 is simply the latest iteration, originally in Article 177 of the treaty, which is like what I took you to in Costa and ENEL, of the power of national courts to make references. And 344 simply prevents member states from submitting disputes concerning the interpretation or application of the treaties to any method of settlement other than provided for the treaties. Then there's the residual remedy at 364, and then 365, impossible to see on the face of Articles 267 and 344 TFEU, and in accordance with normal rules of treaty interpretation. The effect of Article 26.3 ECT is to prevent national courts from making references to the CJEU or to allow members states to submit disputes concerning interpretation or application of the treaties to any method of settlement otherwise than those provided in the treaties. 366, the ACMER ruling is a decision on the constitutional order of the EU in support of the policy of European integration, rather than an orthodox application of the rules of treaty interpretation. And as I do respectfully say, that is what we have seen. It does look as if it really is just policy-led. As such, the ruling of the CJEU is entitled to the greatest respect from an international arbitral tribunal, but such a finding is not in any sense, but such a tribunal is not in any sense bound by the ruling, nor consequently,
complete the paragraph.
Nor consequently can the tribunal find that on a normal basis of interpretation under customary international law or the VCLT, that the dispute resolution provisions of the ECT are incompatible with Articles 267 and 344.
It goes on, and as
Yes.
I understand it, what you get from that paragraph and generally is two propositions. First, that an arbitral panel or a court is not bound by what the CJEU says about EU law.
Exactly.
But secondly, following on from that, actually there is no conflict between the ECT and EU law.
Correct.
Now, the first conclusion only really matters if you then argue the second point. Now, is it your case that the ECT is compatible with the articles of the TFEU?
Yes, completely. And the contention by the EU that it's not, we say, is wholly inconsistent with the EU's treaty architecture and constitutional order. But we have to face the fact that the CJEU has declared that within the EU it is.
No, I follow that.
Yeah. But as a matter of...
Your case, as I understood it
Yeah.
this morning, was that because the EU acceded to the ECT, however it was put,
Yes.
agreed to it, that it can't be argued that it's contrary to
No.
EU
Not at all.
law because they signed up to it.
Yes. And no one thought it was.
It's one of the treaties which
Yes.
as you said a moment ago, part of the treaty architecture.
exactly.
But
But
that's not
the-
sorry.
Yeah,
Sorry,
but
but
it's
the
not the point your
court has-
lordship
The court
was
has said, oh no, it isn't.
But
Yes.
that's not the basis of the Lord Collins' decision. Lord
No.
Collins says we're not bound by what the CJEU says. And if we look at the substance, there is no conflict between the treaties.
correct.
Is that your case? I hadn't understood it to be
Well,
your case.
well, my lord, it's slightly awkward. We have to face the fact that Comstroy has said that the basis of disapplication has to be because there is a conflict. That's the premise of what we face when we look at Comstroy and the argument from the other side. But our primary case is that that there is a conflict. In practice, there's a conflict because of what the Court of Justice said in Comstroy. But on a correct analysis on the international plane, the issue can be resolved without any conflict on the basis of the reasoning here.
I followed the way, I think I followed where you're putting it. I mean, for this decision to be in point, it has indeed to be the case that we have to grapple with whether the ECT is compatible with the provisions of the TFEU, because that's the basis on which Lord Collins and Sir Daniel Bethlehem
Yes,
reached their decision.
exactly. And the short point is, it is inconceivable that, well, there is no normal international law analysis which permits a conclusion that the ECT is inconsistent with the TFEU or TEU.
And we see that punchline in 370, 11 and 12.
Exactly.
They say there's no conflict between Article 26 and
Yes.
Articles 267 and 344, such as to bring Article 30 into play. And then they say it's not necessary to decide whether the effect of Article 16 is
Yes.
matter. So we're very much in the territory you were rehearsing this morning, but only in circumstances where the tribunal is actually addressing whether there is a conflict between the ECT and the substance of EU law.
Yes, and my lord, the Article 16 dispositive point only arises if, contrary to the international law analysis, that it's perfectly plain what the position is, and the EU law doesn't trump everything.
They're not saying that EU law doesn't trump everything, but they're saying that if you look at the TFEU, it's not inconsistent.
Yes.
We haven't really done that exercise.
Well, my lord, the problem is that we haven't done the exercise, but the only inconsistency is the alleged inconsistency is on a totally false premise, we say, because the reasoning in Acmea stood on two bases. One, the specific provisions of Article 8 of the BIT required the application of domestic law, and that meant that included EU law. That's one point. And the other point was it was a treaty made between two member states, and they couldn't take that right away from the EU. But as a matter of international law, the idea that the EU consenting to you doing that is contrary to the EU legal order, I mean, that's completely unsustainable, we say. And that's why I haven't gone through a very detailed analysis. And there was about 4 days of submissions available. I've tried to do it reasonably, in a reasonably focused way. But the idea that the EU makes a treaty, convenes a conference, makes a treaty, has its own detailed architecture within its own treaties, constitutional treaties, on whether or not proposed international treaties are compliant, and doesn't use any of that, and enters into that agreement, and then everyone only realises 20 years later that it's totally contrary to EU law on the most fundamental principles. It's laughable, I'm sorry to say. It's laughable, and it's not in accordance with EU law, with international law, to have a contracting party, a fortiori, the party trying to convene the signature of the convention, the ECT, contending that it didn't have competence, which is what it says in Constroy, to enter into that treaty. It's flatly contrary to the VCLT for it to be entitled into international law to pray that in aid.
I mean, for our purposes, the two, seems to me the two important subparagraphs of the conclusion in 370 are really 9.
Yes.
If the principles in the ACMA ruling apply to the ECT as a matter of EU law, that cannot affect the jurisdiction of the tribunal
Exactly.
under the applicable international law, namely the ECT and the ICSID Convention.
Exactly.
So they're saying that's the applicable international
Correct.
law. And then they go on at 17 to say the fact that EU law has primacy under the principle of Costa does not affect the position that that principle is concerned with primacy over national law, not international law, whether customary law or treaty law.
Exactly. And my lords, there's one factual point, which is factually at paragraph 8.8 on 4810. Now the question is, as a matter of international law, did Spain or did Spain not give its unconditional consent to submit the dispute to international arbitration? There's only one answer available. Factually, it did. And the EU agreed that it could as well in the ECT. So there is really only one answer. We respectfully say that it is available on that point. My lords, can I just end?
Well, you say this reasoning, although obviously it's not binding on us in any sense because it's an arbitration tribunal, it's compelling reasoning.
It's completely vanilla international law reasoning applying treaty provisions in a normal way.
And it's anticipated Constroy.
Yes. And
What is said in 366 and 379 would be said with equal force even after Constitution.
exactly. I was going to do, my Lord of Justice Newey flushed that paragraph out. I was going to do a little reveal at the end. And it anticipated.
I must admit, I still have trouble because I
Yes.
absolutely follow. The tribunal says we're not bound by what the CJEU says.
Yes.
And I see the force of that. But that's only stage 1. Stage 2 is they say, well, let's look at whether the TFEU is inconsistent with the ECT.
Yes.
And we'll form our own view.
Yes.
And we haven't really had that argument.
But we haven't. And my Lord, the reason I've given a very short version, and I've shown you that, firstly, international treaties concluded by the EU are part of the EU legal order and bind the institutions, including the court.
Now,
Pausing there.
if that's the key point, that's not in this reasoning at all. This reasoning is
No.
about looking at Articles 267 and 344 and comparing them with the ECT.
Exactly.
And then they say, doing that exercise, we find there's no problem.
Yes. Well,
Any ordinary principle of treaty interpretation, no
Yes.
problem. But that's
Yes.
completely different from
it is.
the points that you're
Well,
urging on this.
no, my Lord, you're completely right. I hope I'm adopting what they say on that because it makes total sense. And I'm adding fortifying points which I've tried to elucidate, which are the constitutional order of the EU, including the treaty-making power and the consequence of the EU entering into an international treaty, being binding on the court, and that is binding on the court's interpretation of the foundational treaties.
But if we're not worried about what the court says, why are we worried about whether it's binding on the court?
Well-
I mean, if Lord Collins says, forget about what the court says,
I
it's
agree.
interesting.
Yeah.
So that doesn't seem
Well,
to help.
I was cheekily trying to ride the Comstroy horse at the same time and just say that, that does, on an normal international law analysis, it's very difficult to get from the constitutional structure, the CETA opinion, which is exactly the same in terms of applying a treaty made by the EU, applying international law standards and not EU law, exactly the same as the ECT.
And the tribunal isn't suggesting otherwise. The tribunal is saying, we will construe these two treaties together
Totally
to see
understand.
how it comes out.
Exactly. And I would adopt their reasoning just on the bare treaty comparison.
There's only 3 paragraphs, isn't it?
Yes, it's very short. But my lord, I adopt their reasoning, but I would also, that's why I've sought to fortify it by demonstrating that you just can't justify the CETA opinion on a treaty made by the EU that applies international law being fine, and the ECT made by the EU applying international law not being fine, when they specifically consider the same reason.
Yeah.
So that the fact that the CETA opinion found as it did strongly supports, I would respectfully submit, the analysis that there's no actual conflict.
But you adopt 363 to 365.
I do. Yeah. On that side of the argument. Well, also, can I just end, if I may, by going to bundle 8, just to the end of the article by Sir Alan Dashwood in tab 147. And his commentary, he lays out an analysis of how they actually decided the point over the first few pages, which is itself informative. And then at 4403, he has his commentary on deciding the Article 26 ECT intra-EU arbitration issue by obiter dictum. And at the bottom of that page, 4 lines up, on the left-hand margin, he says the complete absence from the debate of the perspective of intra-EU investors, the private parties most directly affected by the denial of the right. So, and he's looking at that in the context of the obiter dictum.
Sorry, I couldn't find that. Where is
Sorry, it's a bottom left of 4403, left-hand margin, the word complete.
Another serious procedural defect. in the
Exactly.
construct. The sentence begins.
Yes,
Yeah. That's the point you made a few times.
yes. And then
That's the point about it being obiter.
exactly. And then there's another separate point above, which we've touched on, but it's at the top of, just above the top hole punch. The constitutional objection is the court chose deliberately to act in a manner falling outside its jurisdiction because the question wasn't referred to it and the parties before it were not involved in an intra-EU dispute. And he then deals with the core argument on 4404 and he refers to the CETA opinion, which I've taken the court to, top hole punch, and that reasoning. And takes a number of points there. And then the intended scope of the international obligations at 4405, we've already touched upon. And then he deals with his, on 4406, between the 2 hole punches, he doesn't understand what must be interpreted as not being applicable means, because that's not something that's very easily matched to the terms of the ECT. And he says, halfway down between the 2 hole punches, the court surely cannot mean that the consent given by the EU and member states to the intra-EU applicability of the mechanism is negated by its lately perceived incompatibility with EU law. And then he brings the conclusion together at the bottom of that page. And the only bit I wanted really to identify to the court is a new point that he raises as his 4th paragraph, the final paragraph. And it starts off as sounding like quite an aesthetic legal constitutional point about direct effect on individuals. He says, 4thly and finally, there's an issue which it is thought has never been fully argued before the Court of Justice, whether Article 344 TFEU, provision of which the court says the principle of autonomy is enshrined, is capable of having direct effect for individuals. More concretely, if the intra-EU applicability of arbitration under Article 26 ECT must be seen as an infringement by the member states of their undertaking in Article 344 not to submit disputes concerning interpretation and application of EU treaties to any method of settlement other than those provided for in the treaties themselves, would this necessarily entail the invalidation, I would say add the words even, but in the eyes of EU law, of the offer of arbitration made to investors by Article 26.2 and 26.3 ECT? Such an infringement of Article 34 would be the fault of the member states that concluded the ECT without subjecting Article 26 to a disconnection clause, as well as the EU itself. Whereas investors who had accepted the offer of arbitration in good faith by commencing arbitration proceedings would be entirely blameless. And one can also say they accepted the reassurance of the offer of arbitration in good faith in making the investments. The disabling of such investors from relying on the unconditional offer in 26.3 would thus have the consequence of allowing a member state to profit from its own wrongdoing. It is hard to think of any precedent where member states have been able in this way to exploit the principles of direct effect and primacy of EU law to gain an advantage in litigation against a private party. In the case law on direct effect of directives, the Court of Justice has always insisted that direct effect flows upwards rather than downwards. In other words, while an individual may rely on provisions contained in a directive that are unconditional and sufficiently precise in proceedings against the member state that has failed to implement the directive properly, this principle does not apply in reverse. Member states' authorities may not rely directly on the provisions of a directive they ought to have implemented, where this would have been to the detriment of an individual. If given binding force through the future ruling on Article 2670 FEU, the position taken by the Court of Justice of Constroy would condone a gross instance of member states profiting from their own wrong through the reverse application of direct effect. Can the Court of Justice really intend such an outcome? My Lords, that is a striking and fair summary of the effect of the judgment in Constroy being taken to effectively have direct effect against individual investors in that way. And for those reasons, that's another reason why, even within the EU's own legal architecture, it is analysed from the outside an astonishing result to have reached. My Lords, unless I can help the Court further,
Thank you very much.
I'm most grateful. My Lord, could we possibly take a 5-minute break so we can all swap positions?
He has to reply, finish.
Oh, he's got to reply first. Yes,
Yes.
Sorry.
Do you want to reply and then we'll have a break?
My Lords, I'm in your hands. I will be 15 minutes. We thought the break may be used to...
Why don't you reply and then we'll break then. We've got to finish at 4:15 today. So one thing I'd like you all to think about is whether we need to start earlier tomorrow. Partly because we can't start before 10, but also it occurs to us that given that the Zimbabwe representatives in the Zimbabwe appeal are going to have the opportunity to at least to comment to some extent on what submissions have been made on behalf of and against Spain. The obverse may also be true in fairness. It may be that you and Mr. Green will say something at some stage. Not encouraging you to do so, you don't have to, don't feel obliged, but it just occurred to us that that it may be that something that could be sort of factored into tomorrow, and that might also lead to needing a little bit more time.
My Lord, we are obliged, and we, certainly on our side, both states would welcome the extra time.
Sure.
But we also are aware that where we don't need to speak, we will not. And so far, I hope if there's nothing else we agree on, we have stayed away from overlapping issues to the extent possible.
Yeah.
My Lord, I will be short. There's obviously a lot one could say.
Of
But
course.
can I start by perhaps addressing just one of the thinking overnight about trying to be helpful to at least one of the questions that Lord Justice Phillips asked me. My Lord, can I just give you two references? You asked me about the governing law of the treaty and then the governing law of the arbitration
Which
agreement
treaty?
of the ECT, and then the governing law of the arbitration agreement that arises out of it. In terms of the treaty and that being governed by international law, that's just VCLT Article 2.1a. My Lord, I won't take you to it because I don't have time, but I will, if you look at the case of GPF and Poland, GPF, that's a decision of this jurisdiction, GPF in Poland, Bundle 3, tab 42, paragraph 9, you'll see there confirmation that the arbitration agreement that comes out of an investment treaty, so there's a standing offer, then there's an arbitration agreement that comes out of the acceptance by the investor, is also governed by international law. And that was first established in the case of Ecuador and Occidental, which is referred to there, from I think 2006. But that case, so my lord, that's just a reference for you, for your purposes of the question.
Yeah, okay.
My lord, staying on Lord Justice Phillips's question, my lord, you asked a question and I will probably not recollect it properly, so I'm going to try and you'll tell me if I'm wrong. This was the interaction between Section 9 and Section 2. You were concerned that if the analysis I put to you is correct, how does that interact with, or does that undermine Section 2 of the SIA and Section 1 of the 1966 Act, if I've understood you correctly. My lord, the first point to make on that, if I may, is that would be true of any award. That's not just an ICSID award, because Section 9 asks the question, was there an agreement to arbitrate? The second point is, my lord, your question is exactly the point we're trying to make, which is arbitration awards get through immunity under Section 9, not under Section 2. So we do not see an inconsistency there, because it really should also always be about Section 9. That's the first point. We also don't see an inconsistency with Section 1 of the 1966 Act, because, my lord, as I emphasized strongly in the beginning of my submissions, that stage you do not even reach until you've cleared the immunity hurdle. And you will not have cleared the immunity hurdle because of Section 9. My lord, I know that Article 16, there was some time spent on that, and that's Article 16 of the ECT. Could I just briefly give you our submissions on why we say that is not applicable here, and we do not believe it is a conflicts clause either? Could I invite you to go to it, my lords? It's in bundle 7. Tab 106. Page 3611 of the bundle. And while you're doing that, my lords, could you also keep handy my learned friend's skeleton in paragraph 81 of that skeleton? When one looks at if we can start with the text of the treaty in Article 16, you'll see that it is about treaties which concern Part 3 or 5 of this treaty, which is the investment protection regime, my lord. So it's about treaties that both have an investment protection regime. And that's why, and my lords, as I think my friend even confirmed around 1254, I timed it, the EU treaties do not have an investment protection regime. So this provision doesn't apply, which is why in his skeleton, when he discussed it in 81.2, he said, to the extent that the TFEU covers the same subject matter of the ECT, quod non, and then he carries on. Well, we say that they don't have, the TFEU does not have an investment protection regime, and that provision doesn't apply. That's our first point. The second point is, my lord, we submit, despite what the Swiss court may have said, this is not really a conflicts clause, it's more of an interpretation clause. The conflicts clause very clearly will say this is disapplied, as I showed you when I showed you Article 30, and I showed you one of the cases. So that's our submission on Article 16. My lord, there was a lot of critique of the CJU based on its reasoning on Professor Dashwood, on the Advocate General's opinion, and internal inconsistencies that my learned friend articulated and took you through. Obviously, I should say Spain does not agree or accept that critique of the CJU, but we say neither here nor there, because we were not sure whether they were just prejudicial statements or whether they were actually inviting this court to find that there is no conflict. That was a question we had on this side. And if that is what is being done, which I now think is the case, then we say it's frankly too late. Because as I said at the very beginning of my submissions on section 9, the judge very clearly accepted there was a conflict, and that part of his judgment has not been appealed or challenged. And I can show you it again if you would like. It's at paragraph 87 of his judgment. It's the first sentence. I consider that there is a clear conflict between the EU treaties as their application to international arbitration and the ECT.
Sorry, can you
Now,
just
as
bear
I-
with me while I find
course,
the
my lord.
judgment?
That's in tab
No, I put it loose. So it's paragraph 87.
87, my lord. You'll remember this, this was a paragraph I used
Yes,
as a starting point, because what I was trying to, and the reason why we did not address whether there was a conflict or not, is we did not understand this to be challenged. And so I took that as my starting point to then say, well, where the judge goes from that is really the question for you. My lord, but even if you are now willing to accept that that's what you're being invited to do, we reserve our rights on that, because obviously we do not think that that was being challenged and that's not been done properly. We say that what the CJU has done and what it does when it declares a conflict, and why we don't think the Kabbalah reasoning works, is that it is announcing an authentic interpretation. And that authentic interpretation, my lord, is a very specific, has a very specific meaning in the VCLT. You'll find the provision at 31(3)(a), which is treaty parties can, by subsequent practice, provide an authentic interpretation of how their treaty relations work. There's a lot of alarmism about the whole ICSID system coming down, etc., etc. This is just about the masters of their own treaty relationships telling you what they believe their treaty means. And my lord, this is a new reference.
Sorry, just before you go on.
Yeah.
That means you're not accepting that point of Lord Collins. Because Lord Collins, I think, says, well, who cares about what the CJAU says?
Yes.
We can make up our own minds. You're not accepting that.
I'm not accepting that. But my lord, that is only if you are willing to entertain the idea that you are being invited to write a judgment that says there's no conflict.
And on that point, can I understand, do you say there is a conflict because the Court of Justice has decided something and that binds? Or do you say there's a conflict, or I suppose the real question is, on what basis was the judge approaching it? Was he approaching it on the basis that there's a conflict because the CJAU says so, or was he approaching it on the basis that there's a conflict because of the substance of the dispute?
I'm trying to understand. I'm afraid I don't know what was going on, but I can tell you what we submitted to him. A very similar argument was played out. And we said to him that this is not for you, my lord, and he seemed open to that idea, as you can tell by his conclusion, for him to go behind the reasoning of what essentially treaty parties are telling you their treaty means.
And I follow that point, but that again is inconsistent with Lord Collins.
It is, my lord.
Lord Collins definitely goes into whether or not there is an underlying...
He does, and we don't agree with that. But that's only if you accept that, as I said to you, we say that part of the first instance judge's finding has not been challenged. So we don't think we get there. But if you do get there, I'm about to take you to a paragraph to explain why we say you can't go behind what the CJU, as expressing the 27 EU member states' understanding of their treaty relationships. Finally, can I just take you to?
Well, the judge's reasoning, as I read it in paragraph 87, about 4 lines down, he says, if intra-EU arbitration is contrary to EU law principles governing either the primacy of the CJEU or EU principles generally, then this must and can only arise from the EU treaties themselves. I cannot see how it can arise in any other way. Therefore, if that is the case, there must be a conflict. So that's the basis on which he says there was a conflict. And then he goes on to say,
But that doesn't mean
that doesn't mean
that,
that either the CJEU or the EU treaties have effectively trumped the ECT.
quite right, my lord, and that's why I said that the key question for you was, what is the effect of that conflict? Is it, as my friend seems to be urging you to conclude, that there is this two legal orders that govern interpretation of a treaty? one that's internal and one that's external that binds you. I've never seen any book that said that. I don't remember him taking you to a book that says there's two laws of interpretation of treaties. But that is what we say. There is only one law that governs treaty relationships, and that is international law. And the whole point of taking through the rules of EU primacy and then Article 5 was to explain why, if you accept the conflict like he did, that is that's applying the rule of EU primacy, which is the rule of treaty conflict. But of course, you may come to a different conclusion. But the point is, the starting point was conflict. We did not think that was being challenged. But if it is, then can I just show you why it is not open to a court or anybody to go behind what the treaty parties say is an authentic interpretation of their treaty relationships.
Sorry, which treaty parties?
The EU member states, by the way.
Sorry, so
Yeah, to the ECT and the TFU. Can I just show you? It's volumes 9, my lord. Tab 164.
I don't see number 164.
That is all right.
No,
I've got
that's a great start.
No, neither do I.
Dr. Mark very kindly will pass them up. I apologize for that. Cool, sorry for that. Do you have it?
Yeah,
now?
we've got
Cool. My lord, what I wanted to show you was on page 4826, paragraph 16. It's on the right-hand side as you look at the page. It starts paragraphs 2 and subparagraphs 3 and B, which is referring back to 31, 3A and B. Will represent forms of authentic interpretation. These are things that happen post the treaty relations, the treaty and the agreement being concluded, whereby all parties themselves agree on, or at least accept, the interpretation of treaty terms by means which are intrinsic to the treaty. And here it's a practice, which we say as contained in the CJU's cases on primacy. And as a result, the parties' authentic interpretation of the treaty terms is not only particularly reliable, it is also endowed with binding force. It provides ex hypothesi the correct interpretation among the parties in that it determines which of the various ordinary meanings shall apply. It has been argued above that Article 31, Para 1 does not permit the interpreter to legislate or revise the treaty, but authentic interpretation presents a different situation, since the parties to the treaty are their own masters.
But it's a bit of a jump to say that doesn't just apply in relation to a dispute about the TFEU, but it applies in relation to whether there is a conflict between the ECT and the TFEU, because the parties to the ECT definitely haven't all signed up to this.
I know, but it's very important. What I'm saying this represents in terms of authentic interpretation is the rule of primacy. What that rule does in terms of this application is obviously not interpretation. So it's just a rule of primacy that the treaty parties, based on the TFEU, through the CJU, are telling you is their conflict law. I don't know if that, I wasn't saying that it also goes to explain about
This doesn't address at all an issue where there's a conflict between the signatories of the treaty. I mean, what we have here is what is essentially a political dispute with respect, in which it would appear 22 of the 28 on one side, 5 are on the other, and I think Hungary is not playing ball at all. This doesn't really deal, as I read it, with an issue about where they don't agree amongst themselves as to the correct interpretation of their treaty. Am I wrong?
My lord, that's pre-construct, but I'm not sure that we accept that there is this 22-5 result. The declarations you were taken to were pre-construct for the 5 parties. And all they said was, because it's still being decided by one of the courts, we will hold fire. But they did accept ACMEA in that same declaration. So we do not accept that this idea that what the CJU said in relation to the conflict with the ECT does not represent the unanimous view of the EU member states. And you've not been shown any document that says they don't agree with that.
But following up from my Lord Justice Newey's point, I'm also struggling. I can see that the EU member states, possibly speaking through the CJEU, can authoritatively determine what their treaty means. But why does that mean that they can authoritatively determine what that means in relation to another treaty, to which they are not the sole signatories? I mean, surely that would be an extraordinarily unilateral and high-handed result.
My lord, can I, if I may, just do a little Q&A, as it were? If it was just another treaty between 2 EU member states, I don't think you would find it as extraordinary. I think what if I may assume, you're finding extraordinary is that you're saying it's an ECT with many other non-EU members. And that's where my bilateral analysis kicks in. Because what we're saying to you is that the best way to analogize this is the EU member states amongst themselves saying, this is how our treaty relationships work and how they're prioritized when they're conflicting. It's nothing more ambitious than that to affect third-party member states. Now, of course, you may take the view that it does, and then you have to conclude
if it's a multilateral treaty, the fact that they between themselves may have agreed something bilaterally doesn't help, does it? And that's really the point I think my Lord's putting to you, that there are a whole load of other countries, including the UK, which are signatories to the ECT, which aren't members of the EU.
Quite right, my lord, but our analysis does not impact those non-EU member states. They've never complained about this either for that reason. What we are saying is that...
They accepted your analysis.
Well, my lord, they could have said this, they could have sued under the ECT if what we're doing is incorrect and it harms them. But what I'm saying is that this is analogous to, well, it's the member state parties in relation just to their relationship under the ECT that is being disapplied. It's not more than that. It's not impacting the UK, Kazakhstan, or any other non-EU member. My lords, just one more point, if I may, and that's really this. It's my learned friend approach to treaty interpretation. I don't have enough time, but can I just make some high-level points? The first is, there is no doubt that conflict rules exist. I've taken you to multiple international law texts that show that. They also show that those conflict rules, as a matter of international law, are not just in the treaty, they can be in practice, and they can be concluded and set out in subsequent practice after a treaty is concluded. But if my learned friend is right with his analysis of, well, why didn't you agree a disconnection clause? Why didn't you modify? Why didn't you do this under the VCLT? Then essentially you would never have a very good conflicts argument, because you would just say, well, you should have just always put a reservation in. So there is no idea of this mutual exclusivity of what one can do when it comes to outcomes. And I want to take you back to the text, the leading international law text, which told you that when there is a conflict, the parties are encouraged to terminate, but before that termination, those obligations are disapplied. So when he took you to the sunset clause, that's all well and good, but the text that I took you to told you that before termination, the disapplication occurs. My lord, it's the Schmallenbach's text in volume 8, tab 141.
You took us to that in your main.
I did, as long as you have it. But I just want to remind you, my lords, with this idea that because there's termination, the suggestion was there's something inconsistent. It's very clearly here, says, states must terminate the agreement, but even before termination, and this is the book on international law and treaty law, even before termination, its provisions are not applicable. So there's no idea, and I've not seen anything suggested of mutual exclusivity as to how these provisions work.
And I know you need to sit down. Can I just be absolutely clear in my own mind? Going back to the Vienna Convention, you don't suggest Article 41 applies.
No,
Do you suggest that Article 30 applies?
no, my lord.
Because
Because that's, you may recall, I showed you that that is a default provision, and we have a special conflicts rule of EU premises. And yeah, and it's the same subject matter as well. No, my lord, we don't
It's
accept
not
the
the
same
same
subject.
subject
We do not accept the same subject matter. My lord, you've got the references in what I said in my submissions when I took you to the same book, which showed you the problems, the limitations of Article 30 as being a default rule that is limited, and that often you have to go outside to see what the treaty parties have agreed.
So to be clear, once again,
Yeah.
you're parting company from Lord Collins because he says, well, we're not bound by what the CJEU says, and then he says, well, we'll look at principles of interpretation by reference to the Vienna Convention, and doing so, we conclude there's no problem.
Right, my lord. And when the reason why I took you to the text I did, there is nothing inconsistent or incorrect as a matter of international law to go outside the VCLT when it comes to conflict rules, because those conflict rules in there are not supposed to be comprehensive. My lord, can I just end by correcting something and jumping back to ground one, and then I will sit down unless your lordships have further questions. My lord, the Chancellor yesterday said that the SIA had a list of treaties or proceedings that were excluded or repealed, to which the SIA didn't apply. But I just want to make clear that that's not what the provision says. It's a list of excluded matters, so proceedings to which it doesn't apply. And that is, of course, a significant difference because the 1966 Act is not listed there. Unless your lordships have any further questions, I didn't have anything more to say.
My lords, could I just correct one tiny point, because it's a bit important and it wasn't addressed by my learned friend in opening. It's just on the point he made about Article 30 and Article 16. I think my Lord Justice Newey has it already probably, but the point is in Article 16, the overlap of subject matter is confined to Part 3 and 5, which is fair and equitable treatment, and so it's remedies and the ISDS provisions in 16.
My lord,
And for 30, you have to have same subject matter of the whole treaty.
I don't
So-
think that, okay.
Just to be clear, they're not the same.
Yeah, they're not the same, and my lord, I never said they were. What I'm saying is that Article 16, the ISDS regime, does not exist in the TFEU. So that particular provision cannot apply, because it can only apply to provisions that, treaties that contain that regime. Yeah, as Mr. Green's captain says.
Right, well, I think we should definitely take a break. It's all transcribed on the speaker. So which end do you think? 3:30, possibly just slightly after.
Court rise if able.
I moved my stuff over there. I'm sorry, there's a copy of yours back. I'm sorry. Sure. Do you want to move? Is that all right? No, sure. Have you switched over the cloth? That's my line.
I think I may have. I think I may have said that. Oh, that's probably Do you need your
You can use it for your.
Your water reserves.
I'm not cool. I've got 3 appeals. One to the Council. Supreme Court of Appeal. It's not a small thing. I'm ready for a holiday. Gosh.
They are all, yeah. Yeah, they're all there. They're made aware.
Not supposed to.
Put it on the front of my notes.
Your joke will work very well now. Yeah, the only one is
Someone in attendance.
you only get the points. I'll leave it in your hands. As long as you're happy. That's fine. Yeah, that's fine. As long as it does in fact hit the side. Marilyn Monroe.
yeah, probably.
Is this perfect?
That's really done, yeah.
I'm going to do it.
Court rise if able.
May it please the court. In this appeal, I appear for the board parties, together with Mr. Kennelly and Ms. Drummond. My learned friends, Mr. Moulan, King's Counsel, Mr. Tompkins, and Mr. Radzitis, appear for Zimbabwe. My lords, whilst it may appear slightly odd for me to be going first,
Yes.
since Mrs. Justice Dias ruled in favour of my clients, the reason for that is, as your lordships have no doubt understood, that we do not seek to uphold the learned judge's order for the reasons she gave. And since the learned judge found against my clients on both sections 2 and 9, we are effectively the appellant. My learned friend graciously recognised that, and you will hopefully have seen the correspondence that was sent to the court last week reflecting that in terms of the order of submissions. My lords, I propose to, in the light of my Lord Justice Flo's comment earlier that we've got to 4:15 today, I've spoken to Mr. Moulan and we agree that it would make sense to begin at 10 tomorrow morning if the court is able.
Yes, we will sit at 10 tomorrow.
And we also would suggest that we try to reserve perhaps 15 minutes in case there are any additional points that the other parties want to raise at the end in Sir reply or whatever. I say that on the basis that, as the court will have seen, both Spain and their self-parties have left quite a lot of the work on Section 2 and Section 9 for us. And those are obviously important points and they will take a certain amount of time to develop.
Sure.
So what I was proposing is that I will speak for the remainder of today, which is just under 45 minutes. I will then probably have an hour and a half, perhaps a little bit more tomorrow morning to conclude my primary submissions. Then the learned friend will make his submissions and then I will have about half an hour for reply. And that should be okay.
Happy with that arrangement, Mr. Moulan?
Subject to seeing exact timings, my lord, that corresponds to what we have discussed, yes.
Yeah, jolly good. Okay.
My lord, it is my submission that Zimbabwe is not immune from the adjudicative jurisdiction of this court for 3 independent reasons. First, because by ratifying the ICSID Convention and thereby agreeing to its Article 54, Zimbabwe submitted to the jurisdiction of this court in respect of applications for registration and enforcement of ICSID awards. That's the Section 2 ground. Secondly, additionally or alternatively, Zimbabwe is not immune because these proceedings relate to an arbitration in which to which Zimbabwe has agreed in writing. That's the Section 9 point. And that has 2 aspects to it in response to Zimbabwe's submission that it did not agree to arbitration with my clients. First, we say that under the terms of the ICSID Convention and on a proper interpretation of Section 9 of the State Immunity Act, the award is effectively conclusive evidence of the valid arbitration agreement, and Zimbabwe cannot, as it seeks to, go behind the tribunal's determination of its jurisdiction. And an English court cannot reopen the question of jurisdiction and rehear it, as Zimbabwe urges. Secondly, we submit that properly understood, this is in a way, a different way of arriving at the same result, properly understood, the decision of an ICSID tribunal on its jurisdiction is final and binding and creates an issue estoppel which precludes Zimbabwe from disputing the validity of the arbitration agreement. So again, where ICSID awards are concerned, and only where ICSID awards are concerned, Section 9 is automatically satisfied and there is no rehearing of jurisdiction. Then, my lords,
And is that because the effect of the convention is that, unlike a New York Convention arbitrations,
radically
is
different.
that the decision of the tribunal as to its jurisdiction is conclusive.
That's right.
It's effectively final and binding.
And I will come on and
So it's
explain.
an issue stopping.
I will come on and explain in some detail why that is.
Yeah, sure.
My Lords, our third submission is that it is clear, for the reasons which my learned friend Mr. Green, King's Counsel, explained yesterday, that the 1966 Act abrogated adjudicative immunity in respect of the recognition and enforcement of ICSID awards. And we submit that nothing changed in that regard coming into force of the 1978 Act, again, as my learned friend submitted. We say the way in which that was given effect through the 1978 Act was through section 23(3), and I will develop why we say that is a clear statute-based route here, which is complementary to and in addition to my learned friend's harmonious interpretation route. That will be for tomorrow, obviously. My Lords, with your leave, I will develop the points in that order which corresponds to the order of the sections of the Act.
Yeah.
And then I'll pick up a last point, which is Zimbabwe's ground 6 at the very end, which you may recall that Zimbabwe says that it has one of those exceptional MICLA points that it should be allowed to run, so that even if you don't find that it is immune, you should remit to the commercial court and not bring the application to an end by dismissing it. And I will explain tomorrow that that just doesn't get off the ground, and there's no good reason to waste yet more court time on this.
Yeah.
So let me turn straight away, my Lords, to our submissions on section 2. As I said, our case is that Article 54 of the Convention is a submission to the jurisdiction of the English courts by Zimbabwe for the purposes of section 2 of the 1978 Act. And I'll make that submission good in the following way, with my Lord's leave. First, I will show you what section 2 requires. Secondly, I will then look at Article 54 of the Convention, and I will take that in two parts. I will outline the applicable principles of treaty interpretation, and then, bearing those principles in mind, I will explain why we submit that it is clear that Article 54 constitutes a waiver of state immunity as international law. And then thirdly, I will apply the Section 2 requirements to Article 54 properly interpreted to make good that it is indeed a clear and unambiguous submission to the jurisdiction of the English courts for the purposes of registration and enforcement of ICSID awards. So, my Lords, can we start then with Section 2 itself? That is to be found in Volume 1, Tab 4, at page 52. Volume 1, Tab 4, page 52. Whilst you're turning that up, my Lords, it may be of assistance. Inspired by London friend Mr. Green, I have produced separate versions of our skeletons, so that, because I'm going to ask you to look at various passages, and Mr. Moulin has done the same, so that you'll have them separately, so that you
Well, they
can
say imitation is the grossest form of flattery, Mr. Harris. They say imitation is the grossest form of flattery.
Quite right. So,
Thank you very much.
Section 2.1, a state is not immune as respects proceedings in respect of which it has submitted to the jurisdiction of the courts of the United Kingdom. And Section 2.2, the state may submit after the dispute giving rise to the proceedings has arisen, or by a prior written agreement. And we saw in Section 17 that a prior written agreement can include a treaty or a convention. So the key dispute in relation to Section 2 itself between the parties is whether there is a need for a particular form of words or specificity in the language of the treaty provision said to be the submission. Spain has submitted that, firstly, an explicit reference to submit or submission is required, and secondly, that the submission must concern a particular complainant and a particular complaint, and that's in paragraph 44 of Spain's skeleton. And Zimbabwe takes a similar but not identical position, contending that the subsection requires any submission to specify the jurisdiction to which the state submits and the matter which is the subject of the submission. That's paragraph 51 of my learned friend's supplemental skeleton. In my submission, my lords, both my learned friend's respective points are demonstrably wrong in that regard. My lords, can I begin in that sense by showing you the decision of the Supreme Court in NML and Argentina, which is at volume 3 of the authorities bundle. It's the very first tab of volume 3, tab 33.
Yeah.
Tab 33, the very first tab of volume 3, NML and Argentina, decision of the Supreme Court. It was a case, as the court may be aware, about Argentinian government bonds that were acquired by a US vulture fund. And the terms of the bonds provided, we can pick this up in the head note at the end of the second line, the terms of the bonds provided that a final judgment in New York would be enforceable against the defendant in other courts in which it might be amenable to suit on the judgment. Now, 3 key issues arose for determination in the Supreme Court, but the key one for our purposes is whether or not, on a true construction, certain provisions of the bonds constituted an agreement to waive immunity and to submit to the jurisdiction of the English courts. And on that issue, not on all the issues, but on that issue, the Supreme Court was unanimous. Lords, can we take up the analysis of this point in the speech of Lord Phillips of Worth and Travers at page 1106 of the bundle, please? Paragraph 55 of the judgment. At H, just below H. So issue 3, do the bonds contain a submission to the jurisdiction of the English court in respect to these proceedings within the meaning of section 2 of the 1978 Act? So directly on point with what your lordships have to consider. So paragraph 55, Lord Phillips begins by noting that section 2.2 of the 78 Act varied the law of what was capable of amounting to a submission by a state to the jurisdiction of the English court. And the issue on this appeal over the page on 107 at the top, the issue on this appeal is simply whether, on the true construction of the relevant provisions of the bonds, Argentina submitted to the jurisdiction of the English court. The bonds were governed by New York law, and that law applies a narrow construction in favour of the state to the construction of a term which is alleged to waive immunity. Well, that's an important point. So they're applying New York law, not international law, when they're construing these terms, but New York law applies a narrow construction in favour of the state, so pro-immunity. Now, paragraph 57, you get the key provision that they're interpreting. So it starts by saying there's a degree of common ground, but then he sets out, Lord Phillips sets out the relevant provision. The related judgment shall be conclusive and binding upon Argentina and may be enforced in any specified court or in any other courts to the jurisdiction of which the Republic is or may be subject by suit upon such judgment. Now, just pausing there, one can immediately see that that is similar to Article 54 in several respects. Argentina was accepting that a judgment entered on the bonds could be enforced against it in any court which, but for immunity, would have jurisdiction over it. There is no language of the type contended for by Spain. The word submission isn't there. The word waiver isn't there. Nor is there any specific jurisdiction identified, a particular state jurisdiction, as my learned friend Mr. Moulin suggests must be the case. And in paragraph 58, Lord Phillips recalls that Mr. Justice Blair at first instance had considered that this provision constituted a submission to the jurisdiction of the English court, inasmuch as Argentina unambiguously agreed that a final judgment on the bonds in New York should be enforceable against Argentina in other courts in which it might be amenable to suit on the judgment. Lord Justice Aikins in the Court of Appeal did not agree, and he had held that that was neither a waiver of jurisdiction nor a submission to the jurisdiction of the English court. This is in paragraph 59. Lord Phillips says, "I do not follow this reasoning. It seems to rob the provision of all effect. Mr. Justice Blair held that this agreement was more than a mere waiver, and I agree. If a state waives immunity, it does no more than place itself on the same footing as any other person. The waiver of immunity does not confer jurisdiction where, in the case of another defendant, it would not exist. If, however, state immunity is the only bar to jurisdiction, an agreement to waive immunity is tantamount to a submission to the jurisdiction." Then he sets out, rather like Mr. Justice Blair, in this case, Argentina agreed that the New York judgment could be enforced by suit upon the judgment in any court to the jurisdiction of which, absent immunity, Argentina would be subject. It was both an agreement to waive immunity and an express agreement that the New York judgment could be sued on in any country that state immunity apart would have jurisdiction. England is such a country by reason of what was at the material time CPR 6.209. The provision in the first paragraph constituted a submission to the jurisdiction of the English courts.
Yeah.
Now, Lord Collins was the other member of the court who considered this issue specifically. And that we turn on to 1131. And then from Mr. Green took you to 1129. I want to look at 1131 further on in the speech of Lord Collins. And he held in paragraph 128 that this clause that we've just been looking at was the clearest possible waiver of immunity, because Argentina was or might be subject to the jurisdiction of the English court. So again, Lords, the other Lords didn't address this. The other justices of the Supreme Court didn't address this.
Would you read on it?
What you have is a unanimous Supreme Court on this point in relation to a clause which did not use the language submit or submission or refer to the English courts specifically. They were in no doubt. If we go back to Lord Phillips of Worth and Travers, there was a second clause as well in that case, which the Supreme Court considered. And that clause was also held to constitute an additional and independent waiver, but of both adjudicative and execution immunity. You see that from paragraph 60. And in paragraph 61, halfway down paragraph 61 on page 1108, you see Lord Phillips says, thus the second paragraph constitutes an independent submission to English jurisdiction. Both jointly and severally, the two paragraphs amount to an agreement on the part of Argentina to submit to the jurisdiction of the English no doubt among other courts. Now, so Lord Phillips construed the clauses separately and held that the second clause was an independent submission. Now, Zimbabwe rather ambitiously tries to make something of the fact that there was this second clause. Says, well, it's only because of that that Lord Phillips found that the first clause was a waiver. But that, I'm afraid, is...
Well, you found clearly there was a waiver irrespective of, and he goes on to say that what's more, there's a waiver, there's another waiver as well. But he doesn't suggest anywhere, does he, that the second point is sorry, that the first point is dependent on the second.
He does not. What I believe my learned friend would say is that Lord Collins in 129, so we looked at 128, taking a point against myself, what my learned friend would say is 129, Lord Collins says the waiver is confirmed by the second paragraph. But that is after he's already...
That's that maybe a very clever way of putting it, but the fact is Lord Mance agreed with Lord Phillips and Lord Clark agreed with Lord Phillips, so it would be 3-2 in any event.
Lord, if the point arose, that is right. In my submission, it simply doesn't work.
It doesn't arise in your case.
So Lord, can we just go back to 1108, paragraph 62? And it's a point I'll come back to later when we turn to Article 54, but I mentioned that New York law adopted this narrow construction. And Lord Phillips says this conclusion does not involve a departure from the narrow approach to construction required by the law of New York. It gives the provisions as to immunity in the bonds the only meaning they can sensibly bear. And that, Lord, I will be submitting in due course, is also true of Article 54, albeit that's to be construed as a matter of international law, obviously.
Yeah.
So, Lords, in a nutshell, similar clause held to be a clear submission under Section 2 by the Supreme Court. Section 2 does not require specific words or a specific court or a specific proceeding. All it requires is that on a proper construction, the state has agreed that a claim can be brought in against it in England. And that must be right, since a convention is given as an example of a prior written agreement in Section 17. And as my Lord Justice Phillips observed, whether yesterday or the day before, I forget, it is highly unlikely that a convention would be specific to a particular complainant or complaint.
Or indeed necessarily a particular state.
My Lord, exactly. And in fairness, my Lord, my learned friend Mr. Balloch did relent and accept that it could be a class of disputes and a class of complainants. In answer to the question from my Lord, that's for your note is day 1 transcript, page 109, lines 11 to 13. Now, we do not accept that there's any requirement of additional specificity, but even assuming that there were, Article 54.1 meets it, as I will now come on to develop. In essence, that is what Article 54.1 deals with. It's the class of proceedings is recognition and enforcement proceedings in respect of an award, and the class of complainants is foreign investors party to an ICSID award. So, turning then to Article 54 of the ICSID Convention, as I said, the first part is to address you on the proper approach to treaty interpretation. My Lords, it's essential to the determination of these appeals to interpret treaty provisions, and the ICSID Convention in particular. And whilst I'm sure that this court is familiar with the rules of treaty interpretation, and that is no doubt why not a great deal of time has been spent on them so far, in my submission, it is nonetheless sensible to begin by reminding ourselves of those rules before we go on to apply them. My Lords, it's common ground between all the parties to these appeals that the relevant rules for the interpretation of treaties are to be found in the Vienna Convention on the Law of Treaties, and Articles 31 and 32 in particular. Now, we have those in the bundle at Volume 7, Tab 101, but for the purposes of what I want to show you, it's convenient to take them up in the judgment of Mr. Justice Butcher in the Tatneft decision in the Commercial Court. That is in the same bundle that you have open, Volume 3, apologies, at tab 43. The very last tab, we go from first to last. My Lords, this was a case relating to a New York Convention award against Ukraine, which was sought to be enforced here, and Ukraine took an immunity point on adjudicative jurisdiction. Tatneft said Ukraine was not immune due to Section 9, and Ukraine said it was because the tribunal didn't have jurisdiction. And Tatneft sought to defeat that by saying that Ukraine could not now argue jurisdictional points it hadn't raised in the arbitration, by analogy with Section 73 of the 1996 Act. So that's what the case is largely about. But let's look at the relevant passages which start on page 1620. Lord. In the judgment of Mr. Justice Butcher, paragraph 25, he sets out Section 9 of the State Immunity Act. Then he says 26, the arbitration agreement, it comes from Article 9 of the BIT. Then 27, an important point, bilateral investment treaties are treaties between two sovereign nations. It's been common ground before me, however, that such treaties, and the BIT in particular, can give rise to an agreement in writing between the state and an investor for the purposes of Section 9 of the State Immunity Act. The way in which this is analysed to come about is to regard the consent of the state to arbitrate claims by an investor as a unilateral offer to the investor to arbitrate, which is then accepted by the investor when it commences the arbitration against the state. That is a classic position in this regard, and you can see the reference there to the Occidental case and the Gold Reserve and Venezuela case, both of which adopted that analysis. 28, it has also been common ground that enforcement proceedings such as the present are proceedings which relate to the arbitration for the purposes of Section 9, and there's a reference there to Svenska. Perhaps I can add here, I'm sure it's a point that the court's well understood, but just in case, because it goes to the unique nature of ICSID. ICSID arbitrations do not have any seat in the familiar sense of that word. It is a properly delocalized arbitration system. There's no curial court, no court of the seat, no curial law in the sense that we're used to thinking of it in a New York Convention context, no state court supervision. That is another aspect of it which is radically different from arbitral law, ICC rules or LCIA rules, which we might all be more familiar with. So turning now to 1623 and to paragraph 38, my lords. Mr. Justice Butcher here talks about the approach to interpretation of the BIT, and he borrows from the analysis of those provisions by Mr. Justice Bryan in the GPF and Poland case, which was common ground between Mr. Foxton, as he then was, and Mr. Eadie, who were arguing this case. What these provisions actually do, if you compare them to the VCLT Article 31, it tracks fairly closely. But let me just pick up some points. One, it's for the court to interpret, this is just below C, it's for the court to interpret the bilateral investment treaty in accordance with international law, the principles contained in Articles 31 and 32 of the Vienna Convention, which codify customary international law. Two, Article 31 sets out the primary rule of interpretation. Little 1, a treaty shall be interpreted in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. That's its is the treaty's object and purpose as a whole. 2, little Roman 2, the context for the purpose of the interpretation of a treaty shall comprise, in addition to the text, including its preamble and annexes, and then there are some other things which aren't relevant for our purposes. The context, what's important from our purposes is that the text, the whole text of the treaty is relevant for context. So you look at the provision in the whole treaty,
Yeah.
including its preamble and any annexes. Then paragraph 39, because 3 and 4 aren't on point for, certainly for our side in this appeal. 39, the rule of interpretation is textual, not teleological. That is, quote, interpretation must be based above all on the text of the treaty. And that's a reference to the Libya-Chad decision of the International Court. Accordingly, the text is presumed to be the authentic expression of the intention of the parties and is not to be substituted for or overridden by the presumed intention of the parties. Now that's already a warning regarding travaux. And Lord, then paragraph 40, could I perhaps, rather than me reading it, could I perhaps ask you if you'd read paragraph 40 to
Should we
yourself?
read 40 and 41 to ourselves?
Perhaps read 41 as well.
Yeah. Yeah.
So Lord, a few points to emphasise here. First, you can only, I emphasise only, look at travaux to confirm the meaning resulting from the application of Article 31, i.e. the ordinary meaning of the terms in their context and in the light of the treaty's object and purpose. You cannot use the travaux to change or contradict the ordinary meaning you arrive at from Article 31. If and only if you conclude that the Article 31 meaning, the ordinary meaning, is ambiguous or manifestly absurd, then you can use the travaux to help you determine what the term means.
But if it's clear, you can't contradict it. If it's ambiguous, you can use the travaux to discern what it really means.
Correct. And my lords, the Article 31(1) is the cardinal rule, the holistic exercise. It's a single combined operation, text, context, object and purpose. And they're all mandatory. We put a reference in our skeleton to the JTI Polska decision on that, paragraphs 26 and 27 of that judgment, if support were needed for it. But the purpose of Article 31 exercise is to identify the meaning of the treaty provision, which is then deemed to be the authentic expression of the contracting party's intentions. It is not to search for the subjective intention of any one or more of the drafters. And that's precisely why Article 32, which allows recourse to travaux for limited purposes, cannot be used to substitute or override ordinary meaning. And that's critical in this case, as you'll come on to see. My lords, in the interest of time, I'll just ask my lord, perhaps, if you have a moment overnight on a similar point, that we've got the Czech Republic and EMV decision of Mr. Justice Simon in the bundle at tab 29, and at page 987 of that, paragraphs 16 and 17, Mr. Justice Simon recorded his views on these topics and particularly referenced the writings of Sir Gerald Fitzmaurice, the former legal advisor to the Foreign and Commonwealth Office and Judge of the International Court of Justice, making clear the reasons why it is dangerous to seek to ascertain the alleged subjective intention of the treaty parties.
Sorry, could you give me the reference again?
Apologies, yes, it's in tab 29 of the authorities bundle, which is in volume 2.
Paragraphs.
At page 987 is the relevant section, which is paragraphs 16 and 17.
Good.
Lord, if one wanted to think of it in a domestic analogy, it is not unlike the parole evidence rule and the dangers of that with which we are all familiar.
Well, none of this approach is very different to our general approach to interpretation.
Yes, I think that's fair. Yes, there are slight nuances, but in general, what one is looking at is the ordinary meaning of the words in their context and purpose. But the reason I say it's extremely important to keep it in mind is both because it's mandated as the approach by international law to interpret a treaty, but also because you are going to be deluged by my learned friend with Travaux. He's put all of the Travaux into the bundle, despite decrying teleological interpretation and accusing us of teleological interpretation for looking at the words. My learned friends start from the Travaux and work back from there to say what he says the meaning of Article 54 must be.
You're providing us with a Travaux umbrella, are you?
Well, your case is 54 is Article 54 is sufficiently clear that we shouldn't look at the Travaux.
Indeed, my lord, that is my case. But I just wanted to set out the parameters so that there's no doubt about it at all, because when we come to it, you're going to hear a lot about
Well, if
Travaux.
it is sufficiently clear, then the Travaux aren't admissible, are
They are, but only to confirm.
they? Yeah, sorry,
that
they aren't
ordinary
admissible to contradict what it clearly means.
Correct. You don't have to look at them, but you can to confirm.
So if we
seems
looked
well-
at, sorry, I'm sorry.
Sorry, go on.
Now, if we looked at Article 54 and we thought it was clear, and we then looked at the Travaux and the Travaux said, oh, it actually means something else, so that's not admissible, is it?
It is not admissible. No.
No, that's the
In
point
fact-
I had in mind.
If you think the ordinary meaning is clear, looking at it to confirm is a meaningless exercise.
Certainly in this case, that is true.
What it seems to suggest is that in any case you can look at it. It's not saying, I mean, we might say that parole evidence is inadmissible, you can't even look at it. Whereas this, as I understand it, is saying you can look at it.
You can look at it, but you don't need to, and you can't look at it, most importantly, if the meaning is clear, to try in any way to undermine
And that's the
that
purpose
meaning.
for which you're looking at it.
Yes, but you're allowed to look at it, my lord is right.
Because you may like to say, by the way, that's exactly what everyone intended.
Yes.
So
But
I'm obviously right.
As you will see in that passage that I referred you to in Mr. Justice Simon's judgment in the writings of Sir Giles Fitzmaurice, he explains precisely why that it is fraught with danger to try and seek much from Travaux, particularly a convention like this being negotiated by all manner of parties with very divergent interests and picking bits from. So that's the approach to interpretation. May I take a couple of minutes to then just deal with Article 54 so that we can knock that on the head? So, my lords, let's, if we look at the text of Article 54, which we can look at in Bundle 1, behind the 66 Act, which is where we've been picking it up. It's tab 2. At page 41, it reads, each contracting state shall recognise an award rendered pursuant to this convention as binding and enforce the pecuniary obligations imposed on that award within its territories as if it were a final judgment of a court in that state. Two core aspects to that. First, all contracting states, it says each contracting state, all contracting states have agreed with all other contracting states that they will do these things. And that's made good, again, by the Supreme Court's decision in Mikula, paragraph 104, where the Supreme Court held in terms, it is clear that the specific duties in Articles 54 and 69 of the ICSID Convention are owed to all other contracting states. And the point that I think my learned friend took me to yesterday, the convention scheme is one of mutual trust and confidence, which depends on the participation and compliance of every contracting state. Secondly, second core aspect, the content of the agreement is that they will each recognise and enforce awards, including awards to which each other is a party. So, my lords, in our submission, Zimbabwe and the United Kingdom, for these purposes, have each agreed that they and the other contracting states will recognise and enforce ICSID awards, and that contemplates necessarily that the courts of one contracting state will exercise, and indeed be obliged to exercise, jurisdiction over another to recognise and enforce awards. The language is unqualified, doesn't operate only in respect of certain awards, or only when enforcement is sought against certain parties. So, learned from Mr. Balach's submissions about it only being directed to investors, and we'll come back as Zimbabwe adopts the same point. It applies to all ICSID awards.
Well, that's why it doesn't say each contracting state shall recognise an award against that contracting state.
No.
So it's not limited to recognising awards against yourself, as it were.
No. Well, that was a point that was taken below.
Yes.
In our case, but I don't think it's pursued.
No, it's not taken, but that was the point the judge dealt with, I think, yeah.
My Lord, so by agreeing to Article 54, we submit Zimbabwe has agreed with all other contracting states, including the United Kingdom, that all other contracting states, including the United Kingdom, will be obliged to recognise and enforce awards, including awards to which Zimbabwe is a party, like the award in this case, and that agreement to the United Kingdom exercising jurisdiction to recognise and enforce an award to which Zimbabwe is a party is a submission to the courts of the United Kingdom for those purposes. And just a final point, perhaps, that we can finish on. There is no preservation of adjudicative immunity in Article 54. Contrast immunity from execution, which is expressly preserved in Article 55. That is unsurprising because the obligation in Article 54 to recognise and enforce is inconsistent with the maintenance of adjudicative immunity in and of itself. So, my lords, that's perhaps a convenient moment.
Very well. 10 o'clock tomorrow.
All rise if able.
Say how smart these are.